A job site slip and fall on a snow-covered ramp led to a negligence lawsuit. Evidence that the ramp was later replaced with stairs was inadmissible as proof that anybody was negligent. But what about as proof of who had control over the ramp at the time of the accident? That was the question in the First Circuit case of Clausen versus Storage Tank Development. In the late 1980s, Goudreau Construction Corporation hired Eric Clausen for a pile-driving job at a fuel terminal facility. The facility was owned by Storage Tank Development Corporation and operated by C3 Incorporated. During his first day on the job, Clausen slipped and fell on a snow-covered ramp. As a result of the accident, Clausen suffered from a spinal disc herniation that required 5 surgeries. Clausen filed a diversity-based negligence lawsuit in New Hampshire's Federal District Court, naming Storage Tank and C3 as defendants. At trial, one material issue was who had control over the ramp at the time of the accident. Clausen asked to admit evidence that Storage Tank, prompted by C3, had replaced the ramp with stairs in 1992. The district court admitted the evidence but gave the jury a limiting instruction explaining that the evidence was only admissible as proof of control, not as proof that anybody was negligent in maintaining the ramp. The jury ultimately found for Clausen, and Storage Tank appealed to the First Circuit, arguing that the district court erred by admitting the ramp replacement evidence.